So one common thing that landlords and tenants fight about is the security deposit. Was enough ever paid? Was it applied properly? Did I get a refund soon enough? These kinds of things lead to real court time litigation. We're talking all about security deposits. Let's get started. So naturally, your first line of defense for any security deposit issue is going to be your lease. If you're in the need of a great lease for a Texas rental property, check in the video description below. We provide a lease to our clients. If that's something you're interested in discussing with us, we're happy to help you. But when it comes to your lease, you need to know how to use it. And one thing that gets overlooked from time to time is the security deposit. One huge no-no is forgetting to take the security deposit. That's basic. You don't hand over keys. You don't hand over a signed lease unless you've got on the table the first month's rent and a security deposit. If you're skipping out on that step, you're really shooting yourself in the foot. You absolutely need to take a security deposit, and you need to take it before the lease begins. If you're hoping to collect it over time or hoping to eventually get it because they promised they would get it to you later, that's a recipe for disaster. And I know there are some of you out there who are saying, but Ernie, I do this all the time and my tenants are great. Well, that's nice, but you're playing Russian roulette with that security deposit. Eventually, it's going to be trouble. This is not something that I encourage. I in fact strongly discourage landlords from beginning leases without a security deposit in place. I get it, times are tough, but that indication to you is that the tenant can't afford to stay on your property. If it means skipping out or spreading out the security deposit, it just means that later on down the line they're going to have difficulty making rent. So this would not be a situation that I would sign off on. If there are no show with that security deposit at the beginning, that's a no-go on that lease. The next issue that landlords vary on is the amount of the security deposit. And I get it, not every state is like Texas where I practice, where we really don't have a limit on the amount of a security deposit. I know some states do have those limits, and if that exists in your state, you need to know what those limits are. But if you don't have a limit, you definitely don't want to shortchange yourself. Too many landlords don't take a suitable security deposit, and they leave themselves vulnerable to costs or issues that pop up from non-payment. So certainly never take less than a full month of rent. It might be attractive to certain tenants if you're offering a half month's deposit or a couple of $100 here and there. Just understand that the less you have in deposit, the less security you have. It's in the name. It's a security deposit. And if you're not taking at least 1 month's worth of rent, you're setting yourself up in the event that 1 month of rent doesn't get paid. My recommendation is at least a month. Some people like going a month and a half or 2 months, depending on credit issues. But my advice on that is if there's already a credit problem, taking a bigger security deposit may not cure that. It might. And so on a case-by-case basis, you can figure out if that works for you. But personally, if someone has employment and credit issues and, evictions in their past, that's just not a good sign. That's not a tenant that I would accept. Make sure your criteria explains as much. But yes, I do know of some landlords who choose to take higher security deposits when there's a few dings on someone's application. In any case, don't ever take less than 1 month of security deposit for your rental property. Additionally, don't forget to give us a like if you're enjoying what you're seeing here. If you've learned something, if you have a question or a comment, leave that for me to answer later. I respond to every question and comment that's posted here. And if you haven't subscribed yet, please consider subscribing, especially if you're interested in our third point. Don't touch the security deposit. So many landlords get in trouble by deducting for costs that the tenant owes during the lease term. Hey, I'm all for deductions once the tenant has left. If they left unpaid utilities, or they left damage to the property, or perhaps unpaid rent or fees, absolutely, those deductions are great. But during the tenancy, you should not make any kind of deduction from the security deposit because that reduces your future security. Instead, if the tenant owes something during the lease term, bill them for it, send them a notice of default, and collect it. If you're unable to collect it, don't pull it out of the security deposit, issue a notice to vacate. You could probably even pull it out of a subsequent payment of rent if you have an application of funds clause, but never, ever, ever pull it from the security deposit until the tenant has vacated. The funds of the security deposit should stay in place until the tenant is gone, because now you don't have anything to hold over them in terms of some kind of threat of eviction when they've already left. Leave the security deposit funds untouched throughout the tenancy and only begin to make deductions once they have left. If there's things that you can charge them during the tenancy, charge them, enforce those parts of your lease, but not at the expense of the security deposit. Make sure that it's always through notices of default and ultimately a notice to vacate if they simply refuse to pay the money that is owed. Once they're gone, anything that they owe, definitely deducted from the security deposit, but during the tenancy, just don't touch it. Also, don't just assume that the security deposit belongs to you. The fact that you're holding it doesn't mean you get to hold it forever. You need a valid reason to keep any portion of that security deposit. Definitely in Texas, the property code is very clear here. The state presumes you will give back that security deposit. It does not presume you get to keep it automatically. And if you've got it in your head that somehow the tenant has to earn it back or be a good tenant in order to be entitled to it, I mean, that's not what the law says at all. You, the landlord, need a justification for keeping a single dollar. Make sure that you go into this deal understanding that you are holding the security deposit as money prepaid by the tenant, not as your automatically earned income. At the end of the tenancy, once you've calculated any valid deductions in accordance with your lease and in accordance with state law, then you can begin to reduce the amount of that security deposit. And if there's a balance, you should promptly, generally within 30 days, return that balance to your tenant. But if you can't find a single valid deduction that complies with your lease and with state law, then you give the whole thing back. It's not yours automatically, even if the tenant breached once or twice or 10 times. The fact is you must find a valid deduction every time, otherwise you cannot keep it and you must return that deposit. Finally, don't get cute with the deposit at the end of the lease and just approximate this and approximate that and I'm going to guesstimate the rest of this and then send you whatever I feel like. That's a recipe for disaster. I tend to tell landlords to separate their deductions in one of three categories. One is the red category. This is the absolutely you can never charge your tenants for A, things that were already damaged or broken before they got there, or things that you broke during the tenancy, or things that are defective now due to normal wear and tear and ordinary use. The fact is some things are just going to wear out. Like carpet, happens all the time. And if that carpet's old, say 8 or more years old, there's very little value left in it. There's probably nothing you can get out of your tenant. That's just the cost of doing business. Some things just wear out over time. And that doesn't mean that your tenant, even though they were the last ones to use it, are legally responsible to restore it. Now, there are other things that are yellow. They're kind of jump balls, I call them. They are maybe things you can charge to the tenant because maybe they did that, or maybe it's worse than it was when you first leased it to them, but there's not a real bright line to make that determination. Anything that's a maybe is a gamble. If it's a maybe, you really got to ask yourself if it's worth the fight, because litigation can be expensive. And if it's a maybe to you and it's a maybe to the judge doesn't give jump balls. You have the burden to prove that it was a valid deduction. If it's still a maybe for that judge, it's actually a no. So don't ever leave things to a guess. Make sure you are absolutely certain. Those are the bright green deductions. If you've got a bright green deduction, that's a green light means go. It's absolutely the tenant's fault. If you can prove the state of X, whatever it is that was damaged was brand new when the tenant took it, or was in excellent condition and now it's completely destroyed or in terrible condition, and you can prove the change in that condition, and you can prove that the damage results from non-normal use or not from ordinary wear and tear, maybe it's negligence that you can prove, then you've got an absolute bright green. You can charge your tenant for that. So for example, a broken window. If the window was intact when you leased it to the tenant and it was otherwise a perfectly sound window but ends up broken, that doesn't tend to happen from normal use or ordinary wear and tear. Broken windows are pretty easy. Holes in the wall, pretty easy. Now, if it's tiny holes from little nails, don't be ticky-tack about that. You're probably not going to get anything for that. But if you've got massive gaping holes, sometimes doorknobs go right through the wall from misuse. Sometimes people install like televisions or other things that they screw into the wall, and when they remove, they damage the wall. Those kinds of things are absolute bright green. They need to be repaired. And so unless you've got a whole bunch of these, as opposed to a whole bunch of yellow or bright red ones, you don't really have valid deductions. But anything you can prove was absolutely caused by the tenant and exceeds normal use or normal wear and tear, those are bright green charges that every time you can deduct from the lease. But make sure you can tell the difference between the things that you absolutely cannot, the things that are 50-50, and the things that you absolutely can deduct. If you're unable to determine that on your own, you're going to need some help. Make sure you have help before you set yourself up for failure, because a wrongful withholding claim can be expensive. And even if you win, you may win a judgment against someone who claims your house wasn't damaged and that they were entitled to a full refund. But even if you win, sometimes you can't collect your judgment against them. You've got more to lose. So to prevent that sort of thing, you're going to want to keep accurate records of the condition of your property before your tenant ever takes possession. And then when it comes to security deposit, don't play games. Unless you've got bright green, absolute slam dunk deductions, send the refund. Refund the rest, or refund the whole thing and just avoid a silly fight against a tenant against whom you really can't collect anything because they don't have anything to lose, whereas you've got an entire rent house full of value to lose in litigation like this. I hope you see the value in thinking ahead of time when it comes to your security deposit and how best to manage tenants and the use of that security deposit when the time comes at the end of a lease for you to either issue a refund, issue that itemized deduction list, or both. For additional information about how leases operate and what you can do to improve your landlording skills, YouTube seems to think that this video right here is perfect for you. Watch it and all the other content on our channel. And until next time, landlords, happy leasing.